Hello, hello, hello. This is Tony McRaven coming to you from Chicago. As usual, today, big day, opening statement. Sarah Boone. Let's see what happens here. Let's see if I can find a link. Let's see if I can make this thing happen. It should be interesting, but that doesn't mean it will be. It could be fascinating. It could be horribly boring. Who knows? We'll find out. All right. Let me find my thing here. We got that. We got me. We're chillaxing.
I really don't care because I'm the victim.
Okay.
Don't disrespect. Just saying.
All right.
Don't give a shit about what that one says. This is my life.
Yeah. And all I gotta
talk about that victim's life.
That just was reminiscent of what I've seen so far of this defense. I don't have snacks, but I do have Uber Eats. Uber Eats, it's time you sponsor me. I've been sponsoring you for a couple of years now around the world.
Behavior in this case is disgusting.
Just a few things I need to get off my chest before we start. I mean, with the obvious.
I don't know how to put this, but I'm kind of a big deal.
Challenging it.
Okay, in what way?
In a good way.
I don't know when this thing gets started. Get that out of the way. Plus, I anticipate some of these moments. Maybe even one of these.
Ma'am, are you a whore? I object to the relevance of that, Your Honor.
All right. What?
I'll tie it up real quick, Judge.
All right, go ahead.
You're not a whore?
What's up, everybody? Randy Nicole, morning. Yeah, I don't have snacks. I don't have anything good anyway. I've got healthy stuff. Ah, that's a good point. That's a good point. We should mention that.
There shall not be any cutting of trees. Don't cut any trees. I'll pass the order. No cutting of trees, no felling of trees in Patna number 12.
Yeah, we just need to establish some ground rules around here before this thing starts. Also this.
Why are you unnecessarily wasting the judicial time of this court?
And this.
If you didn't know, y'all stink. Okay, that's just my opinion.
This is a little pregame prep here. Oh.
I don't know who he thinks he is, talking to anybody like that.
Your Honor,
Listen, you're going to agitate me if you lie to me. I saw you. I'm going to tell you right now, I'm going to tell you one last time. You are going to agitate me if you lie to me. I saw you. Ma'am, you didn't say the cat jumped on his wiener, did you?
Oh, good Lord. When are they going to get started? I've only got so many clips. Okay, who am I kidding? I got a lot of clips. Yeah. Oh, good point. We might as well get that off our chest right away. Just for the record, so everyone knows. Where are we finding it? Where is it now? Oh no. There it is.
Any objection?
All objections.
That's a good thing to get out of the way. Just for the record, everyone has all objections about everything. Oh, we have rules. We have rules here. No pearl clutching. No cutting of trees. I think that's it. I anticipate that this might get used.
Girl. Barnett, girl, no, don't do that. Just, I'm gonna mute you now, Miss Jones. All right, now, no more girl, Miss Barnett. Now you tell me.
Oh, good Lord. They're not starting. They're not starting. So you know what happens, don't you? You know what happens in this circumstance. Well,
Can you
this
please state your name for the record, ma'am?
These nuts.
Okay, thank you.
But more to the point, we have to play this. A fine little ditty brought to you by Kelly. Called It Gets Worse.
Pretrial. Ma'am, are you a whore?
Speak of the devil.
There were drugs involved that were given to me that ended up being glue. Like, I smoked some glue and stuff. I thought I was smoking crack.
Let's go. You didn't say the cat jumped on his wiener, did you? Sit down and shut up. Shut up. Shut up. Cat jumped on his wiener. Cat jumped on his wiener. Shut up. Cat jumped on his wiener. Cat jumped on his wiener. Shut up. Cat jumped on his wiener. Cat jumped on his wiener. Shut up. Cat jumped on his wiener. Cat jumped on his wiener. Shut up.
I do believe the cat jumped on his wiener loop is my favorite.
Can you just let this go for once? For once? Okay, back to the
Mr. Sharks.
Somebody put the Bandcamp link up. I can't find it now. Oh, this is perfect. We're starting now.
Judge Simpson will tell you that being a no, we just have one question, are you a hoe? Mrs. Short, so Mrs. Short, so where did you go? We have questions like on the weekends, do you work selling burritos? The law talk with my crew, we here to laugh at you. We see you in court acting all tough. You solve issues and life must be so rough. Without getting into further details, there were drugs involved. I thought I was smoking crack. Yeah, without getting into further detail, there were drugs involved that people were giving to me that ended up being glue. Like I smoked some glue and stuff. I thought I was smoking crack. And talk with my crew, here to laugh at you. We see you in court acting all tough. You solve issues and life must be so rough. And now Kinky Kelly is shacked up in bed with the frugal. Then the cat jumped on his wieners.
Oh, sweet Jesus! What?
Love exciting and new. We are and always will be. The law talk with my crew. Law talk with my crew. We see you in court acting all tough. You solve issues and life must be so rough. Without getting into further details, there were drugs involved. I thought I was smoking crack, but it was just glue that dissolved. Oh man, I gotta get it together because wow, that was messed up. And your honor, I have IBS and I'm bleeding inside and it's really been rough. The law talk with my crew, here to laugh at you. We see you in court acting all tough. Judge Simpson will tell you that being a no, we just.
This today, Your Honor, my health is in jeopardy right now.
What's that?
I have IBS, irritable bowel syndrome, and what's been going on?
Very stressful.
I'm bleeding inside, man.
There is no scandal at Law Talk Nation. You can only pay, get a notification. If you're lucky, it's a spicy fornication. It's another day on Law Talk with Mike. We got pretrial on the dial. Planning always make your chest smile. The pro say can't ever share a file. Defendants are always in denial. He was not driving, he's traveling.
Oh, she probably does.
His reasons and facts are unraveling. It's another day of Law Talk with Mike.
I just push it back 45 minutes. You know how I feel about that.
We are heading into that soft six summer. Did you miss the line? That's a bummer. The soft six never gets smarter than dumber. He's not the man, he doesn't need a number. He was not driving, he's traveling. His reasons and facts are
Reasons and facts.
It's another day of Law Talk with Mike.
Sofa.
It wasn't me.
Courtroom is always popping off. You have a failure to appear and you scoff. Judge Simpson is never going soft. Webster is always showing hard. We are heading into. There is no scandal at Law Talk Nation. You can only pay, get a notification. If you're lucky, it's a spicy fornication.
The 37th Circuit Court is now in session with the Honorable Brian K. Kirkham presiding. Today is Friday, October 18th, 2024 at 8:37 a.m.
Mr. Chapman, you can proceed when you're ready.
Thank you, Your Honor. Before the court is Antonio Glasgow of cases 142009 DP and case 06868DS. In each of these matters, Mr. Glasgow is here today after failing to appear before the domestic relations referee on January 4th, 2021. In the first case, bond is currently set at $997. This is the 7th bench warrant. In the second case, bond is currently $1,494, and this is the 11th bench warrant. He reports no employment. Last payment made on these accounts was in July of 2019.
Okay, I'm assuming that's a yes. Okay.
Recommends that reasonable bonds be set in these matters and they be scheduled for hearing on October 30th, 2024 at 8 o'clock a.m. before this court.
Thank you. Mr. Glasgow, you're before the court charged with civil contempt of court due to your failure to appear at a prior proceeding as a result of your failure to pay child support. Purpose of this hearing is to set a bond that would assure your tenants at the next hearing on October 30, 2024 at 8 o'clock a.m. You will get notice of that in writing. Are you able to post a bond, sir?
Well, actually, like I said, I haven't been down here since, well, the last time I've been in jail was probably like 2019. I had the court date that he was talking about, but it was during Corona and it was a video court date. And it was some crap happened. My baby mama ended up turning my phone off that morning and I ended up couldn't get on the video call.
Which is number one, wrong.
So I ended up missing that video call. And then plus since 2021, I've had 3 newborn babies. So I've been just taking care of all my kids. You know what I'm saying? I've started I got my EI, what is that? The EIN number. I just got to go get the, I got to finish doing paperwork, but I have a dog kennel. I breed pocket bullies.
Which is number one, wrong.
Okay,
So,
well,
yeah,
let's get back to my question. Are you able to post a bond?
Yeah, that's what I was getting to, like, because I have no income, but I do have kind of an income. I've been waiting for my dogs. You know, I've been breeding dogs and stuff. So, but right this second, I mean, I can't pay a high bond, but I can pay something. I can give you guys some money, and then when I get out, I can try to get everything straight. And like I said, I got my dog going in the heat at the end of this month. So once I take care of that, then I'd be able to put a chunk down later on in a couple months.
Okay. Well, the court notes that we do have in this case 7 bench warrants in one case, 11 in the other. You haven't paid in now approximately over 5 years. So the court's taking that. Into consideration. What I'm going to do is I'm going to set your bond.
I take care of my kids, sir. I'm with my kids every day, all of them. So, and I've got 9 kids.
Yeah. Well,
So
what I'm going to do is I'm going to set your
take
bond.
care of my kids and child support, you know?
Okay. I'm going to set your bond in both cases in the amount of $500. If you're able to post that, you'd be able to be released. Do you have any questions?
No, sir.
Okay. You're free to go. Have a good day.
You too, sir.
I got nothing,
unmute.
people. Nine kids.
Please unmute.
He's doing what he can to fight the population decline globally.
There we go. Now before the court is Craig Kilborn of case 161402DM. Mr. Kilborn is here today after failing to appear before the domestic relations referee on October 3rd, 2024. For the record, it has now been discovered that Mr. Kilborn was lodged in the Calhoun County Jail on that date. Bond is currently set at $2,195, and this is the third bench warrant. Front of the court's requesting that the bond be canceled in this matter, allowing Mr. Kilborn to be released. He does have a couple other charges that he's got to get taken care of, and front of the court will just take action again if necessary.
Okay. You know, what they're asking, Mr. Kilborn, is that the court would vacate the bond previously set in this matter. That would allow your release on this case. You still have to take care of the other matters that you are in jail on, but at least you wouldn't have anything to do further on the front of the court matter. You understand that?
Yes, sir, I do.
Okay. So the court will follow the recommendation of the front of the court, cancel the bond and cancel and vacate the bond. That will allow your release in the front of the court matter. I will tell you it'll take probably an hour or so to get that done. The paperwork has to come. I have to sign it, and then
I don't know. I'm looking around. This thing's going on other channels. I don't know how I'm behind.
Why are you unnecessarily wasting the judicial time of this court?
There was, and I hate, God, I hate this. He's on what's a dick pussy, dick pussy, dick pussy, dick pussy, going back and forth between texts with one another, and I never want to hear it again.
Always time for corn music. This hat is Futeri's fault, among others. I believe Andrew was co-conspirator, and Iris. Oh, I'm just a calibrication. I'm a fine lawyer. They did also get me the bow tie. So I have my complete fly lawyer Halloween costume ready. I take it you don't like my dancing. Okay, I don't have volume though.
Record should reflect you had a bench conference in this case. I
There we
will
go.
adjourn the final settlement conference in this matter to December 6, 2024 at 9 a.m. Jury selection to if necessary, to December 9th, 2024 at 8:30. Those are in person. And the two of you need to send me a memo on the color we're wearing that day.
Yeah. One more thing, Judge.
Yes.
So my client is testing twice a day with the SoberLink. She's requesting to do once a day with the device. The report was tendered to the court. Everything has been going well. She has not had any violations. She has been complying with all of her bond conditions, by Your Honor.
All right, what I will do, and I would do it by stipulation of the parties, once the assessment's done,
Yes.
I can take a look at, or somebody takes a look at that, then I will strongly consider that.
All right, thank you, Your Honor.
Okay.
Have a great day.
All right, thank you. Court call.
Okay, looks like we've actually started here. Looks like she's got a reasonable outfit on. Conservative outfit, that's good. Straight Karen hairdo, check.
William J. for the state.
James Owens on behalf of Sarah Boone.
Tony Henderson, Sarah Boone.
Okay, I can't stream this as the fly lawyer.
I do.
That was merely a
Good morning.
delay
Can you please
tactic.
state your full name and date of birth for the record for me.
Sarah Boone, 10-10-77.
All right. Ms. Boone is seated at counsel's table, wearing a black suit and a pink blouse. She is in custody in this matter. However, there are no restraints that are affixed to her person. So we will be standing when our jury enters and exits. Before we bring in our jury this morning, yesterday the court had reserved on a Richardson hearing regarding Exhibit 2 is identified in the defendant's 5th amended reciprocal discovery exhibit list, specifically 119 pages of records from Advent Health Winter Park that were provided to the state yesterday morning by way of USB drive. Yesterday, the court had ordered that the defense was to provide an edited version of only the records pertaining to anxiety and the lack thereof, or anything pertaining to those matters, but before 9 a.m. this morning. Was that done, Mr. Owens?
Yes.
Okay. Mr. J, have you had the opportunity to review the culled down list of 119 documents?
Yes.
Anxiety leads
What
to
is
constipation.
the remaining of those 119 specific JPEG images, and what do they pertain to?
Observations by the medical personnel on it necessarily apply to the issue of anxiety, as the court had indicated. I did include certain pages that discuss depression issues, as I believe they were related to anxiety. And then I've identified 4 or 5 other pages that are not anxiety related, that may be relevant to the case.
Of those 119 images, how many are being sought? 15? Okay, thank you. State response.
Apparently, these are all just related to a January 23rd, 2018 admission at Advent Health Winter Park. So it appears they're not seeking to introduce any records from other instances that were contained in the records that were first disclosed to the state on September 27th.
You speak of the 81 pages?
Yes, sir.
Thank you.
Nor the new 119 pictures that still not in a PDF form. So of the 15 pages, the first 2 that they list are pages 9 and 10 out of 111. And I believe I've identified them as best I can. However, the Bates stamp from the hospital is over other text, and there is no other Bates stamp. So I'm guessing that it's pages 9 and 10 out of 111. It appears to just be health information sharing sheet like a contract. I don't understand the relevance of those 2 pages. Pages 21, and then they skip 22, 23, 24, and 25 are all part of her initial assessment on 123.18. We don't object to those pages, but for, and I apologize that there's a but for, the fact that at the bottom of page 25 begins her toxicology screening, and that does go into page 26, and they did not indicate that they want to use page 26. However, without page 26, we are going to experience relevancy issues and a 403 objection from the state. And that is because in her toxicology screen, for which she is coming to the treatment to seek treatment for depression symptoms, she is at 165 for ethanol, meaning when converted, it's 0.165 grams per deciliter, over twice the legal limit. It's a central nervous system depressant. We are going to have at least one medical doctor, well, 2. The forensic pathologist will testify for the state, and then our expert on battered spouse syndrome, if we get to that point, is also a medical doctor. She's a psychiatrist, not a psychologist. Will tell us that ethanol is a central nervous system depressant. I believe even the psychologist will be able to get that information in. So we are objecting to pages 21 through 25 coming in without page 26.
If I understand your argument, is it a rule of completeness issue?
Yeah, I mean, in the sense that it applies to documents as opposed to statements. I mean, it is an out-of-court statement, so it is a rule of completeness issue, particularly when the symptoms and the complaints of the patient on that particular day were crying and being depressed and showing signs of using a central nervous system depressant. The rest of the talk screen, pages 27 and 28, they did not list. We are not complaining that they are not including that. Page 29 is another page they listed. That's more of a narrative about her visit at January 23rd, 2018. We do not object. Page 43 is just her vital signs. We don't object. Page 44 is more of the initial assessment on this January 23rd, 2018 visit. We do not object, nor do we object to pages 45, 46, or 47.
What are pages 45, 46, and 47, just for my own?
More of this initial assessment of January 23rd, 2018 was my understanding.
Okay.
Page 48, we are asking again that this be included. Again, I don't believe it's super mysterious why we are going from pages 43, 44, 45, 46, 47, and then skipping page 48, and then going to 49. But we do want page 48 included. On that page includes her height and weight at the time. Page 63.
What's 49? So seemingly that's included.
49 is just some results. Again, it's misleading and doesn't provide full context without what I've described as page 26, because part of the results on page 49 show that she was tested, shows that she was tested for the presence of ethyl alcohol or ethanol, but it doesn't give the results.
Are the results contained in another page?
Just on page 26, the one I previously described as wanting included.
So not following 49 to 50 or 51 sequentially?
No, because the pages they want from the 40s are 43 through 47, skipping 48, and we're asking for 48 to be included between 47 and 49 to make sure it's relevant and complete.
But they are also seeking 49, correct?
Yes.
Thank you.
Just they just skipped 48, just like they skipped 26.
Okay.
Page 63. It appears to be repetitive, but we don't have any particular objection. Page 63 of the 111. Page 108 seems to be another part of the initial assessment from January 23rd, 2018. So we don't object to that. So basically we're asking for pages 26 and 48 to be included.
Okay, thank you. The defense did, or I'm sorry, the state did seek a Richardson hearing yesterday in this matter, and based on binding precedent by the 6th District Court of Appeal, Young v. State, 369 Southern 3rd, 1243. Regardless of the culling down of the records, the court still is required to conduct a Richardson hearing. As to the issue of whether the defendant's violation was inadvertent or willful, Mr. Owens had advised that these documents were obtained sometime last week. He was unable to provide any specificity. He's going to confer with his office. Mr. Owens or Mr. Beck, are you in a position to advise when these documents were first requested, when they were received, and when they were sent to the state? Specifically, any documents pertaining to Exhibit 2, the Advent Health Winter Park records?
Judge, I did check with my secretary, Margaret, and my understanding is I didn't know that was going to be a question about when we actually sent it out. I know it was one of my trips down here. I got Sarah Boone to sign a medical release. We sent it to the hospital. It took a couple of weeks, I want to say. We got it last week. We don't know exactly when. We don't timestamp at our office when something is mailed in, and it was mailed in from the hospital to my office. For whatever reason, the records did not get to Shelby, who was handling that issue, until late. It was yesterday or the day before that she was aware that they had not been disclosed. We provided the copy to the state at that time.
So did these records come in batches? Because my understanding, based on the state's representation and their objections, was that the first 81 pages came on September 27th. Those were provided.
Those were separate. Those were records that some of the other lawyers, one of the other lawyers had received, and we sent them on, but the problem was they had notes on them. So we sent that 81, but it wasn't directly from the hospital. So we were trying to get a more complete, unedited copy of the records. That's why we made our request.
Okay, and when was the error identified in time as to when these items were not sent, such that they were provided via USB yesterday?
Whatever date we gave them is when we realized there was an error, that same day.
Okay, my understanding that would have been yesterday morning.
Yes.
Okay. Anything else, sir?
If I may real quickly, based on the invoice that was sent from the Winter Park Advance Billing Department, it's a separate subcontractor, the request was made on the 27th of September. I suspect they waited until they received confirmation of payment of $135 for receipt of those. So we received those. So it's all been within a couple of weeks. Plus we had the hurricane issue last week, and I think there were issues as to the matter being provided for. I did speak with the state yesterday afternoon after I had a chance to look at the records, and advised them essentially what these matters were in relationship to, and was told that they already had those records and familiar with them. So I don't think there's any prejudice with the state based on our submission.
Okay. Any further argument or positions with regard to the Richardson analysis, Mr. J?
Yes, for the purposes of this hearing, I'd like this stack of documents.
Is that the 119 pages, sir?
No, sir, it's the 81 pages that we got on September 27th, 2024.
Any objection? All right, what was pre-marked A for the purposes of the Richardson hearing will be received without objection as states 1.
Your Honor, there was just a reference that the 81 pages were all marked up by the defense. There's no markings. The issue and the confusion that the state attorney's office still has, though, is page 68 of 81 of these original 81 documents.
If you have a cell phone on, they need to be silenced and turned off, please. If you cannot follow the court's instructions, due to the publicity in this case, I will ask for you to be removed. Does everyone understand? Thank you. You may proceed.
And I realize that I've only had a limited amount of time to review the 119 pages that came in yesterday. And again, it's more difficult to review those because it's not in a PDF where I can word search it and do any of the things that are afforded to us with modern technology. It came in as 119 separate JPEGs. They're not in order. So for instance, when I'm trying to look for page 43 of those 111 records out of the 119 pages, it's not in order. And I've done my absolute best to try and see if this page, which is 68.
Yes. And referring to 68 of the 81 that was entered as one, correct?
Yes, sir. It is sub-labeled within these records as page 2 of 14, and it appears to be a part of her visit on January 23rd, 2018. And in the social history provided, it says alcohol use denies, tobacco use denies, and the other part isn't relevant. And I just haven't been able to find that. And so I'm asking for the leeway to continue to try and search for that particular page out of the 119, so that I may ask that out of the doctrine of completeness and fairness that it be included. I'm just at this point, I've not been able to find anything in the records that says that, and I'm limited in my abilities to cheat with technology and put it, if there's a 119 page PDF and you make it word searchable, you just put in the magic word and it helps the attorney greatly. So that's why there's this confusion, and that's part of why I had to raise this issue. Was just at my first glance of those pages yesterday, I knew that something seemed off compared to what was previously provided.
Okay. Any response?
It has a heading, Your Honor. I'm not familiar with that heading in the documents that I was reviewing. I'll look for it again and I'll provide.
Okay. I appreciate y'all working together on that. So here's what we're going to do.
If I may,
Yes.
We had told the state that we would bring in a printed copy, not the PDF, this morning. But Federal Express, which is the block away, for whatever reason, the road was being constructed. So they closed. So we were there at 8 o'clock to get the copy to the state. We had promised, but we will bring one at lunch. to hand
I
to
don't,
the state.
Okay.
I don't know, but the word on the street
All
is
right.
she needs
Any
to
other
testify
argument
to
with
make her
regard to the
case,
Richardson issue?
whatever that means.
Anything further, Mr. Beck? Okay. With regard to, let me conclude the Richardson analysis first. All right. Thank you both for your positions and your arguments. The court has, as a matter of law, the court needs to determine whether the defendant's violation was inadvertent or willful. Court finds that based on the positions provided by the defense that the disclosure was inadvertent, but I do find that the violation had some level of substantiality to it. But due to the state's review and the defense compliance with the court's order yesterday as to culling down to the pages that we've identified, the court finds that the violation had a limited ability on the state's ability to prepare for trial due to the lack of objections to the majority of the documents, with the exception of page 48 and 26, which are sought to be included. For those reasons, I find that the
that should be
prejudicial
fun.
effect of the substantial disclosure is limited.
It'll probably be a week from now, but it'll
And
be fun when it
I'm
happens.
not going to order the defense, not going to prohibit the defense from proceeding forward on moving these items into evidence. However, I do want to address the 403 rule of completeness issue with regard to pages, 26 and 49 26 and 48 as sought by the state. No objection, Mr. Beck. All right, thank you. So the state's request is granted.
Well, that makes
pages
sense.
26 and 48.
If you're asserting an
will be
affirmative defense,
included,
you got the burden on that.
in any evidentiary documents that sought to be moved into evidence with regard to this January 23, 2018 incident is provided in the 119 pages of item 2 of the defendant's fifth amended reciprocal discovery exhibit list. I will not foreclose the state regarding page 68 of the 81 pages. If they are able to find that additional document, we can address any argument at that time as to why that should be included. Anything further, state, before we bring in our jury?
Judge, the defense team has indicated to me that they intend on using demonstrative aids during opening statement. The ones that I have seen include jury instructions that may not be given and may not be given in the way that the court gives, and photographs that could be coming into evidence I identified at least one that I don't recognize as something they sought to be seeking into evidence, perhaps two. So I believe we should have a discussion about each and every one of those. They should each be marked for the record purposes by letter so that we can refer to them and make a record. I believe it's in the court's discretion, even though I rarely see it exercised in this way in this circuit, to allow the prospective parties to refer to actual exhibits during opening statements. I would urge the court not to allow that. They're going to see them soon enough, but particularly with what they are seeking to introduce, given the motion in limine ruling that the court has already issued, that at this point in time, the latest proffer with the defendant's testimony is not amounting to an overt act that will result in a self-defense instruction, that will result in prior instances of violence coming in, that it would be extremely prejudicial, dangerous, and to use Mr. Cacciatore's analogy, very impossible
For
to
the
put that
signals?
space back in the
I like
suit.
it.
If we amplify our opening statements, which may or may not come to fruition when we start talking about these past instances and battered spouse syndrome, it would be greatly amplified if they're actually seeing exhibits of the defendant's past injuries that she's attributing to the decedent. So I'm asking for us to discuss that.
Response before we go through each photo.
Judge, yeah, the defense is self-defense. Sarah's going to testify that she was defending herself. We believe the court's going to rule we're entitled to put on a case involving self-defense. And under the instruction for justifiable use of non-deadly force and the justifiable use of deadly force,
I'm not discussing the jury instructions at this time.
there are evidence of prior threats, prior events of violence committed under that instruction. Under the self-defense justifiable use.
Here's my concern. Why are we addressing law in opening statement?
Well, I agree with the state attorney. I did pull up a couple of these on the justifiable use of non-deadly force.
That does not answer my question.
Here's my question. Vodka or tequila?
Okay.
The two I'm interested in using and opening is the standard instruction. It is up to you to decide what evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in considering the verdict. You want to read it out?
No, I can see it, sir.
And then the other one is a reasonable doubt is not a very possible doubt, speculative, imaginary, or forced doubt is the standard instruction.
What's your position with regard to those two, Mr. J?
Judge, it's opening statements. We should be discussing what we anticipate to come into the trial, and that's going to be enough of a minefield. It really shouldn't be about the law. We'll both have an opportunity to use the actual jury instructions, which we have not decided upon. We will have the opportunity to use that overhead or any means that we want at the end of the trial during our closings to put up what is actually decided to be the law after the case has been presented. So it's our position that we shouldn't be using demonstrative aids with portions of jury instructions. We're going to have that opportunity to argue how the law applies to the facts at the end, and we will have the correct version. And if the court is following the tendency that I've seen in this circuit recently, we may, in fact, read 3/4 of the jury instructions to them before we even begin our closing remarks. I think it's premature and problematic to be doing that at this time, and it's not the role of opening remarks.
Any other response?
Judge, I've been doing this 35 years. I've had these boards. I've used these boards in opening statements. I don't know how many times. I've said that I would waive introducing the one specific to self-defense, but reasonable doubt is an instruction you gave to the jury when we got started. And then this weighing the evidence is a standard jury instruction that applies in every case.
Are those the standard? Is that the language of the standard instruction?
I have not had the opportunity this morning to pull up the Florida Standard Criminal Jury Instructions off the Supreme Court website due to dealing with motions to eliminate, trying to prepare my opening
Yeah,
statement.
yeah, try that at Emily D.
Things that
Baker,
I
okay?
Should be doing on the eve of openings. I did notice that I did not believe the reasonable doubt instruction was complete just from memory. And I know that's not the complete weighing the evidence instruction either. It's an entire page of instructions for each of those.
Can I see the reasonable doubt instruction, please? Well, here's the first problem. That's the wrong instruction. Florida Supreme Court revised 3.7 earlier this year. That is not the appropriate definition of reasonable doubt. It is not what was read to the jury during jury selection.
That law
3.7
clerk's
now
getting to
reads
talking to.
proof beyond a reasonable doubt, and it does not mean proof beyond all doubt. A reasonable doubt is not a mere possible, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty.
In my experience, I've seen people use
On the other hand, if after
jury
carefully
instructions in just
considering,
this way
comparing,
in opening
and weighing
statement.
all the evidence, there's not an abiding conviction of guilt, or if having a conviction, it is one which is not stable, but one which wavers and vacillates.
That doesn't mean it's
then the
right.
charge is not proof beyond every reasonable
But it's
doubt.
common
You
practice in
must find
civil
the defendant
cases
not guilty because the
in
doubt is
Chicago.
reasonable. That does not track the standard jury instruction. For those reasons, I'm not going to allow it.
Oh, judge is all excited because he wanted to sidestep this.
As long as it, I mean, we're still in the process of working through. The 3.7 instruction speaks for itself. I won't preclude you from using enlargements in closing, but for the purposes of opening, because it doesn't track the 3.7 instruction, I'm not going to allow it.
Well, if it's slightly different, yeah. I mean, get a new one. Although we're here right now, it's not that big of a deal. Just do it verbally then. Get out a damn whiteboard and write it. Hey, don't be knocking Chi-Town. That's my job.
That seems to be the standard 3.9 instructions, or at least portions of it. Response?
Again, since it's not all of it, it's misleading. It's highlighting something about the law when we're just talking about opening remarks. 6 through 10 are optional. We haven't decided which out of the optional instructions 6 through 10 we're going to use.
No, now I'm letting it
We have
in.
not heard the evidence yet.
Just for
So I
that
just
whiny
think
objection.
It's inappropriate to be delving into pieces and portions of jury instructions before we get the evidence. What we should be doing is explaining to the jury what
What are
we
you
believe
talking
the facts
about?
are going to show and the inferences that they can draw from them, and argue the law later.
Ladies and gentlemen, at the end of the case, you're going
Let's bite
to
at the apple,
this
sir.
jury instruction.
Judge,
Think
they
about
gotta
this as
have
you go.
some
I've
guidance
seen it
from the
1,000
law, you know,
times.
that in many ways, we do it where we give them the law at the very end, you know, and I understand the reason for that, depending on the evidence that comes in, but there's standard instructions that are going to apply throughout. And this is just giving them an idea of what their role is in considering the credibility of witnesses. I think it's appropriate. It's a brief statement of a standard instruction that comes in on every case.
Let me move to the photographs before I address the 3.9 issue.
I think for the record, we should mark them.
Okay. Do you want them marked? You want them marked by Madam Clerk, correct? Okay, so let's approach with that first photograph, please. Madam Clerk, yes.
You know, what else are you going to do on the breaks? But take a little trip.
Exciting and new.
Sarah Boone was taken by law enforcement on one of the incidents involving arrest. And you can see this letter right here, which we believe is relevant, admissible.
Next photo.
Exhibit B, which is a picture of Sarah Boone on the back porch, the townhouse in question with her two dogs. That's exhibit C, a blow up of the picture of inside the townhouse showing the sliding glass door as well as the staircase that leads to the master bedroom. That's exhibit D. Is a picture of the large screen TV with 6 or 7 holes in it from where George Torres hit the TV with a bat, threatening Sarah Boone. That's exhibit E. Is a blow up of injuries to Sarah Boone's left arm from George Torres. Exhibit F is a close-up of the wound to Sarah Boone's leg where George Torres stabbed her with a stapler.
Any other further argument with regard to the use of those items pre-marked as A through I in opening statement? Mr. Owens.
Yes, Judge, and I sent you some cases.
When did you send it, sir?
This morning.
I have not received it. Has the state seen a copy of it?
I'm familiar with the case law. I did receive the email. I'm not sure if it indicated who all was copied on it. A separate one, but I'll check.
This is just these two cases. I've been provided Alsaguer v. State, 326 Southern 3rd, 656, Florida Supreme Court, 2021. Lowe v. State, 259 Southern 3rd, 23, Florida Supreme Court, 2018. Yes, sir.
Judge, the court has discretion to allow demonstrative aids. If you look at one or both of those, there was a state wanted to introduce a dummy they were using in a homicide case, which the court allowed. Other cases have allowed photographs and demonstrative aids to be used in opening statements. In the Alsaguer case, which is the 2021 case, trial court acted within its discretion in permitting state's use of a map as a demonstrative aid during the guilt phase rebuttal closing argument in a capital murder trial, where evidence visually demonstrated on the map was not without support in the record. That was actually an exhibit that wasn't in the record. The 2018 case, Supreme Court of Florida, again, the trial court acted within its discretion in allowing a demonstrative exhibit. In that case, it was a murder prosecution. Trial court acted within its discretion in allowing the state to use a mannequin in a demonstrative aid in order to show the position of the gun in relation to the victim's body. The mannequin was used to set out the circumstances of the crime and to attempt to establish aggravation. The mannequin was used to demonstrate the location of the gunshot wounds, the angle of the impact against the skin, the incapacitating nature of each gunshot wound. Advising of the trajectories were anatomical, not spatial, and had a small degree of error where only was slight difference between the victim's size and the mannequin's dimensions. There was nothing to suggest the mannequin was altered to resemble the victim. Court allowed, again, the court's discretion. As you know, we're claiming self-defense, and as part of that instruction, we're entitled to allege prior instances of difficulties and prior acts of violence so that the defendant who asserts self-defense, their state of mind is different from normal. Instructions would read, find that Sarah Boone, who because of prior threats or difficulties with George Torres, had reasonable grounds to believe that she was in danger of imminent use of unlawful force at the hands of George Torres, you may consider this fact in determining whether the actions of Sarah Boone are those of a reasonable person. Goes on to say, if you find at the time of the alleged second-degree murder, Sarah Boone knew that George Torres had committed an act or acts of violence, you may consider that fact to determine whether Sarah Boone reasonably believed it was necessary for her to use violence. We have a good faith belief that the exhibits will be introduced into evidence. They're demonstrative aids to aid the jury in understanding the circumstances surrounding that relationship and the actions that Sarah took and the reasonableness of those actions in light of their history.
Thank you. Any response, State?
Yes, sir.
Yes, sir.
Judge, the standard is it is your discretion, and you will only be reversed if you abuse your discretion in this regard. The state is urging you just flat out.
Oh,
as a
hey,
matter of principle,
shots fired.
To not allow the parties to go into the exhibits during opening statements. They're going to be seeing the actual exhibits in the very, very near future. I mean, we can do this. We can play the videos. We can show gruesome autopsy photographs on the big screen as well during opening statements, but those things are all coming. So we're just asking you first in general, let's not extend the opening statements in that regard any more than necessary. Now, our specific objections are this. With A, which is beneath everything now, but the bloody ear from the prior incident, I believe that is from a body-worn camera, and I think he indicated as much. It was not from her phone. If we get to that point where we know that this piece of evidence is coming in, that would be one thing. But right now, the law of the case is they cannot put on any evidence of prior instances of violence, any reputation evidence regarding the victim, or go into battered spouse syndrome in the evidence until self-defense has been established. And that self-defense must be established by the testimony, and in this particular case, it has to come from the defendant, of an overt act taken by the decedent, which resulted in an imminent threat of great bodily harm or death. And we have had that litigation. We have provided the court the most recent testimony regarding the defendant's most recent statements from the two doctors, and it doesn't exist at this time. So it's one thing for the parties to go into things in opening statements that don't end up coming into evidence. And when
Deny the
defendant does
request,
that, well, under King
or the
versus
midget gets
State, the state gets to point out, look, they made these promises in opening statements and they didn't come to fruition. So you need to disregard everything that you heard that was going to happen in trial that didn't. But the problem, particularly for the state side, is we don't get to appeal. So if we go through opening statements and we have the jurors not only exposed to our words about things that may or may not be coming into evidence, but exposed to 1,000 words per picture, if a picture is worth 1,000 words, that amplifies the error. And it's an error the state has no remedy to fix. So we're asking for A, which would absolutely come into evidence. If we get this overt act testimony, which has not occurred yet from the defendant, then certainly A would come in, and some of the other letters. And there's nothing wrong with them blowing it up like that. In fact, the state has it on their exhibit and will be showing it on the screen as well. There's not a lot of dispute over whether that will come in if we meet that standard of an imminent act or overt threat of an imminent act of danger. B, I'm not sure B was on their list of items that they sought to introduce from the phone. We would argue a picture of her with her dogs on her porch doesn't have any relevance. I don't expect that to be coming into trial, so we're objecting on that separate ground. And then returning back to C, D, E, F, G, H, I. State is all aware of those photographs. We are prepared to introduce them ourselves through the digital evidence. There's no hiding those things. If we meet the threshold for this sort of evidence coming in.
Could you identify those for me? I'm trying to keep notes contemporaneously.
Yes. C.
It was C through I inclusive?
Yes.
Thank you.
B is the only one that is not a photograph of prior violence. It's, I don't know, it wasn't on their list of things that they sought to introduce, and I don't know what the relevance would be of her just sitting there on her porch with her dogs. But A and then C through I, judge, absolutely at the end of the trial, great. Blow them up, use them as much as you want. But in this particular case, with the rulings that the court has already made about this, based on the state's motion in limine, it is very dangerous to allow them to do this when we are not expecting it to be admitted into evidence based on the current state of the defendant's testimony.
Thank you.
Thank you.
Mr. Owens, if you could address Exhibit B, was pre-marked as B.
But Judge, you've already ruled that these things come in and open. Remember that?
No, what I ruled is that you're able to discuss them, address them in opening. Photographs are a totally different kitty.
I said nothing about battered spouse syndrome. I said self-defense. These exhibits come in,
under self-defense. In arguing these, I've said nothing about battered spouse. I'm talking about self-defense.
I understand.
And prior difficulties, prior acts of violence is a standard instruction.
But the overt act requirement remains. I mean, we've reviewed Holland and read it multiple times.
In good faith, with discussions with my client, we believe there is going to be evidence of an overt act. That she was facing imminent threat, and she reacted based on that threat.
Understood. Your response to Exhibit B.
Look at B. Which one?
You didn't say the cat jumped on his wiener, did you?
Did he abuse? Your story is abused.
That's not the issue. The issue is that the state represented that it was not part of your exhibit list.
I believe it is a part of the exhibit list. We got this from the state. They sent over a bunch of pictures of flowers or paintings that they want to introduce that they've listed as exhibits. I thought for sure we put this on there, but the relevance of it is not only did he abuse Sarah Boone, your story is he abused the dogs, and he would threaten to abuse the dogs to control Sarah Boone.
Okay, thank you.
They're checking, Judge.
All right.
On whether they have
The court's prepared to rule at this point in time. Thank you both for your presentations and your argument. The court's had the opportunity to what was pre-marked as A through I inclusive. First, with regard to the portion of the 3.9 instruction, purposes of opening statement is to set the table of what the issues are, what the parties believe the facts and evidence will show. It is not a proper time to be discussing law or elements of law, and that is an element of law that will be instructed to the jury at the end of the case. So the court's going to exercise its discretion for those reasons and prohibit you from using the portion of the 3.9 instruction in opening statement. You could talk about this is a job that you're going to have, but I'm not going to allow you to read portions of the instruction for those reasons at this time. With regard to what was pre-marked as A through I, the Holland case is clear. Before a defendant may introduce evidence of the victim's character, he must first show that there was an overt act by the victim at or about the time of the incident that reasonably indicated a need for self-defense. I understand your good faith belief. I take no position on whether or not you're going to make it or not. That's something that you're going to have to establish. But the concern is that the photographs, some of them are graphic in nature. The lacerations, the sutures, the bruising, facial wounds with bleeding may have such a impact such that the toothpaste cannot be placed back into the tube, assuming that overt act hurdle is not met. The court, again, takes no position on whether or not you're going to be able to meet it because I haven't heard the evidence and testimony. So court's going to exercise its discretion for those reasons. You can talk about it. You can talk about it that she was a victim. You can talk about specific some incidences may have happened, but I'm not going to allow the photographs at this point in time for those reasons, for your utilization of them in opening statements. Any questions or clarifications with regards to the court's ruling? State.
No, Your Honor.
Defense.
No, sir.
All right. Are we prepared to bring in our jury at this time?
Got two other issues.
They've been waiting for an hour and 20 minutes, Counselor.
We intend to play the 2-minute Suitcase video to the jury in opening statement.
State.
Again, I'm asking you to urge your discretion. They're going to hear it in the next 2 days of court. It's within your discretion whether we're going to start using exhibits during opening statement.
What's the other issue, sir?
What the hell is wrong with you?
With regard to the video,
that video is the state's wet
I'm not going to
dream.
allow proposed exhibits to be used in opening statements. It's good for the goose is good for the gander. I'm not going to allow your photographs, not going to allow the state to do anything. You can orally talk about what you believe the evidence and testimony is going to show, but the actual evidence is going to have to be presented here through witnesses or through demonstration and publication after that evidence is admitted. Y'all can approach.
While we approach, can somebody from their team start?
I think it's a good ruling, but I don't know why
Please,
the
I would
state
appreciate
objected
it.
to
Thank
it.
you.
Yeah, let's show the video of this guy dying in the suitcase to kick this thing off. You objected to that? I know that I have some dopey spin on it, but I don't care. Try to argue. I'm confident you can't argue your way out of that. I mean, it doesn't matter. She's guilty as hell. This thing ends in a guilty. I'm not even putting a poll up. It's guilty. And that video is why. Well, there's lots of other evidence, but that video is soul crushing. So all this is a tempest in a teapot. If I was the prosecutor, I'd just be like, whatever, I'll take the first 12 and yeah, they can play the video. They can read instructions. Hell, I don't care. Let's roll. Well, yeah. I mean, she has been denied snacks, which I think is cruel and unusual already. On the upside, I think she will be getting some ramen and sticky buns soon. Yes, I do.
Any reason why we cannot bring in our jury at this time? State.
No, sir.
Defense.
No, sir.
All right, let's stand and bring in our panel.
Just not during the opening. The defense wanted to do it because they think they've got some clever way to. Their idea is get in front of it. It's a bad piece of evidence and disperse it in some way, but it wouldn't work. So they would have some. I don't blame them, but strategically they think, okay, well, we'll take the sting out of it by presenting it ourselves, but it's not going to work. That video is horrific.
Good morning, y'all may be seated. State, do you recognize our jury?
Yes, Your Honor.
Defense, do you recognize our jury?
Yes.
Can the parties approach for a moment?
Yeah, I was out drinking with them last night, Judge. Oops, was I not supposed to do that? They are friendly.
All right, members of our jury, good morning. I want to just confirm before we start this morning that you complied with the court's instructions last night to not have any conversations amongst yourselves or anyone else about the persons, places, things, or charge involved in this case. And then you have not conducted any independent investigation regarding those items. You just raise your hands to confer that you complied with the court's instructions. All right, the record will reflect that all jurors have raised their hands. Members of the jury, yesterday, I told you that you may happen to see the lawyers in the courtroom or in the courthouse going about their affairs. And again, they're not trying to avoid you or speak to you because they're not allowed to. Did anyone happen to ride an elevator this morning with any of the attorneys, either for the state or for the defense? All right, juror in seat number 3 from my left, first row. Yes, ma'am. Okay, thank you. Can you all approach for a moment? And a juror in seat 4, left to right, first row. Yes, sir. Who did you ride the elevator with? Do you recall who specifically, sir? Mr. Owens. Okay, thank you. All right, thank you both for your honesty. I appreciate that. It's something we talked about earlier this week. That's the one thing that we required and asked of you is just be open and honest. And I appreciate both of y'all's open and honesty. During the ride in the elevator, was there anything that you saw or observed that it would impacted you or influenced you in any way Did it have any impact on you? Juror number 3, left to right, first row. Juror number 4, left to right, first row. Okay, thank you. All right, with that, members of the jury, we're going to proceed with opening statements this morning. Both the state and the defense will have the opportunity to present them. I ask that you listen closely to those statements that they're going to provide. But remember, these are not evidence. This is just the party's belief as to what the facts and the evidence will show in this case. After the conclusion of the opening statements, we'll begin with the state's case in chief through witnesses. With that, Mr. Jay, you may proceed, sir.
Thank you. Ladies and gentlemen, what the evidence in this case is going to show you is that this defendant.
Oh, sweet Jesus. We don't have a mic on him.
She was able to do this because at the time of his death, he only weighed 103 pounds. And she did this with the malicious intent to punish him. And then she went up to sleep and left him to take his final breaths on this earth alone. How many breaths those were, we don't know. The evidence is going to show that it was at least for about 15 minutes, because there's going to be 2 videos that the defendant herself took of this event. The evidence is going to show George Torres is dead because in this defendant's judgment, he deserved it. And out of a conscious disregard for whether he lived or died, you will see and hear these videos. What I expect you will hear from a video that began at 11:12 p.m., 45 seconds, on February 23rd, 2020, in Orange County, Florida, is a suitcase on the ground, face down, with the zippers facing the floor. You will hear Sarah, the defendant will say, "For everything you've done to me." Sarah, "For everything you've done to me." Sarah, "Fuck you." And then the defendant laughs. Sarah, "Fuck you." And the defendant laughs. Sarah, "Stupid." Sarah, "That's my name. Don't wear it out." Sarah, "I can't fucking breathe, baby. Seriously." "Yeah, that's what you do when you choke me." Sarah, Sarah, Sarah. The defendant laughs again. Sarah, "I can't breathe, babe." She laughs again. "That's on you." Sarah, "I can't breathe." She laughs again. Unintelligible words. And I would submit the evidence is going to show, because of the intoxication from alcohol, is the next thing she says. Sarah, 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 "I can't breathe, baby." That's what I feel like when you cheat on me. Sarah, "Fuck you." "I can't fucking breathe, Sarah." "You should probably shut the fuck up." Sarah, "Shh," is the last thing you will hear the defendant say to Mr. Torres as he is face down, zipped shut in a suitcase. That, again, began at 11:12:45 and lasts just over 2 minutes. At 11:23 and 3 seconds p.m., there's a second 22-second video, and it's the defendant zooming in on the suitcase. And all you hear during this 22 seconds, after he's been in this suitcase since at least 11:12 p.m., is one more time, Sarah. How did we get to this point where 103-pound George Torres is put into this suitcase left to die? Well, the next morning, the
It really is. I wish I could hear him now. I think it was a strong opening.
Perhaps early afternoon, somewhere in this time range, several hours later. And she goes downstairs and she doesn't see George anywhere, just Torres. And eventually realizes, oh my God. The first thing she does after taking him out, and I believe you will hear a description by the defendants, little legs out. At some point she makes that statement and tries to resuscitate him. Here's gurgling as she presses down on his 103-pound chest, forcing whatever air was trapped in there out and gurgling. The next thing she does is she doesn't call 911. She calls Brian Boone. Who's Brian Boone? Brian Boone is her ex-husband. They share a child in common. And this date, February 24th, 2020, is a Monday. A normal work day for most people. School day for their child that they share in common. But after they got divorced, the arrangement was every other weekend, no co-parent. And that weekend included Friday, Saturday, Sunday. So it's that free schedule. And then Monday through Tuesdays, their child would be her responsibility. And Wednesdays and Thursdays, their child would be Mr. Brian Boone's responsibility. So February 23rd, 2022, the front door of her townhouse, which allows you a view all the way to the back sliding glass door. You're going to see that her kitchen is off to the right, but there's a doorway that you can see all the way through. And on the back side of the kitchen in the breakfast room area, there's tables and stuff. There's also some blue legs sticking out in view. Brian Boone says, check please.
Thank you for helping me.
He doesn't set foot into that townhouse. He does wait outside though, being the good co-parent that he has been. So now, after having first called her ex-husband, after having first waited for Brian Boone to come over, the defendant makes the 911 call. What you will not hear are tears. You will not hear sorrow. You will hear a certain level of concern. My boyfriend and I were playing last night. Put him in a suitcase, and we were playing hide and seek kind of thing. I fell asleep. Found him dead in the suitcase this morning. I don't know what happened. He had blood coming out of his mouth. Don't know if it was an aneurysm. Pulled him out of the suitcase, tried to give him CPR. He was in the suitcase and I fell asleep. He's not awake, he's purple, he's not breathing. There's some instructions about how to do CPR given to her, asking about whether an AED is available to shock his heart. It's too late. He's cold, he's stiff, he's purple. We were playing hide and seek. We were playing hide and seek. This is horrible. This is horrific what happened. Like, what happened? We were playing hide and seek last night and I fell asleep. So she mentions that there was blood coming out of his mouth. And his body, like all bodies in suspicious deaths, was taken to the 9th District Medical Examiner's office and autopsy. What the doctor found was what you would expect after being left in the suitcase, crumpled up in fetal position. He passed from positional asphyxiation, meaning like you're not going to get full breaths when you're crumpled up like an accordion, and environmental suffocation. You don't have to have a plastic bag over your head, tape shut with a full roll of duct tape to seal it off 100% and be worthy of the vacuum of space to environmentally suffocate. It's close enough if you can't get the oxygen and the CO2 coming in and out of your environment. But she also did notice, yeah, he suffered from blunt force trauma on his torso, in his face, his mouth. She'll use words like contusion. We'll help her explain contusions and bruises. She'll use words like hematomas. We'll help her understand for you all that that means bleeding under the skin and blood, what you expect from a bruise. That's why they're running bruise. But it had all this additional trauma. He had trauma on his fingers as well. So now, the sheriff's office, Orange County Fire Rescue show up, and the defendant interacts with the first patrol officer. You will see and hear that body-worn camera. And it's more of the same of what we heard on the 911 call. Hide and seek. It was good. I fell asleep. I don't know what happened. A few hours later, the detectives from the homicide unit of the Orange County Sheriff's Office approach her and are ready to interview her after doing some initial things, which includes grabbing her cell phone off of a counter that was found at a suitcase by Mr. Flores, and giving it to one of their digital forensic examiners, who we'll hear from later in the trial. But it's time to give the first interview with the defendant. So they do the first interview with the defendant in one of their unmarked detective patrol cars there on the scene. And the basics of this remain the same, but there's a little more elaboration, as you would expect from trained detectives versus getting the 911 call taken. But the basics of what the defendant tells them is we had wine, we painted, we drew, we did puzzles. The particular wine we had was a Chardonnay from the Woodbridge winery. The bottles, plural, are in the trash. We started about 4 p.m. after Mr. Torres went to the store. Puzzles, art, listening to music, enjoying each other's company. We were just literally just enjoying one another's company. The other bottle of wine that was left over from Boer wasn't even half full. So the description she is saying is 1 bottle of wine and plus a fraction of a bottle of wine left over from the night before. Ladies and gentlemen, not all bottles of wine are made the same. Many of us may envision what you would expect at a restaurant. Those are 750s, 750 milliliters. That. Bottles of wine that were recovered from the defendant's trash can were 1.5 liters. So the equivalent of 2 standard bottles of wine. A 1.5 liter bottle of wine is 50 ounces. Given that a standard serving of wine is 5 ounces, you can begin to do the math. And there's receipts. The day before, Saturday, February 22nd, 2020, there is a receipt from Publix for a bottle of Woodbridge wine for $9.74. And then Sunday at 12:17 p.m., there is another receipt for $9.74 for a Woodbridge Chardonnay bottle of wine. And then at about 5:30 in the afternoon on February 23rd, again, there is another receipt for the same bottle of wine for the same price. And those 2 bottles of wine were recovered. They're going to be produced to you in evidence, and you will see that they are, in fact, Magnum bottles of wine. So that's the context that we're dealing with when we hear things like, we only had 1 bottle of wine, and we finished what was left in the bottle of wine from before. Well, ladies and gentlemen, there's 2 1.5 liters that apparently were consumed by a 103-pound man and the defendant, who is in the same weight class. Plus, if you believe that the defendant and the decedent would leave leftover wine from any given day, any additional wine that was remaining from the 1.5 liters from Saturday. Ladies and gentlemen, that's a lot of wine. So in that context, we were just having wine, enjoying each other's company. At one point, we play hide and seek. She says she didn't zip it up all the way. There was enough room, in her words again, there was enough room for his little fingers to get out. We were still having a good time and whatever. And basically, Mr. Torres is stressing out about jobs, his ex-wife, about money. And so they're just doing puzzles and doing things to keep his mind off of it. Doing art, playing with the dogs, dancing with the dogs, playing hide and seek. We were always trying to outdo each other where we could find each other the best. When they started playing hide and seek, she went up to the shower and then got tired of hanging out in the shower and came down, and that's when she found him playing around in the suitcase. We both thought it was funny. I'm going to zip you up. 2 little fingers could stick out. And she went upstairs thinking, he'll get out, we're going to have sex and go to sleep and call it a day. It was a good day. She insists that they had wine, but we're not drunk. You will be able to assess that for yourselves when you hear the recording she made. No ill will between us last night. Last argument, maybe last week. Don't really argue. We came home, drink, smoke, did art, listened to music, play with the dogs. We drink what we can afford. We used to be able to afford liquor, but now we can only afford wine. And that's how that day ends with the police. She goes and sleeps and stays at her ex-husband's house the night of February 24th and 25th. What they are doing, and by they I mean Orange County Sheriff's Office in part, is going through her phone. That's when they discovered the 2 videos that I just described for you. And there's other things in the phone, which I will discuss with you in a little bit. But she's summoned in for another interview, and she sits down and gives another interview on February 25th, now Tuesday. She does describe past instances of violence. You're going to hear about that. She's going to say, Mr. Torres had hit her with a curtain rod about a month ago. Since then, though, like, we've been good. I've been good. She describes that he comes at her all the time. He comes at me. So it's either I flee or I try to go upstairs and go to sleep. That's usually what it is. I don't know if you talk to Brian, her husband, about any of that, but most of the time I flee and I go over there. There's a discussion about why she stays with him, and you'll hear that for yourself. She will say that she doesn't really want to drink. She just takes an occasional drink. She drinks to placate him, Mr. Torres. She says that you're going to see phone videos of Mr. Torres smashing her TV in the past, like a month earlier. You may see that too. But she doesn't get drunk. When she drinks, she likes being non-compos mentis, her words, not mine, having her wits about herself. Then she gets to the hide and seek again and describes that they've played it 3 times before, but had never zipped one another shut in it before. And they were really just running out of places to hide because it's just a townhome. She does not remember, according to her, she does not remember taking any photos or videos of the night's events. At this point, they ask her, well, would you like to see it? And she says, I can't watch this. I flipped him over. I flipped him over, and that's where it was. Guys, this is killing me right now. That's why I flipped it over between the 2 videos. I didn't do anything intentional. Discussion over whether he had enough room to get any of his fingers out from the zipper. My intention was not to leave him there. We both got in there. Both of us were in there. When she went upstairs, my plan was not to, quote, he'll be up here any minute. My plan wasn't to leave him in the suitcase. Why is all this going on? It's the drinking. That's what it is. It's the drinking. I thought he was okay. Guys, that's how we were with each other. Nobody understands our relationship. This whole suitcase thing never happened before, though she described it happening before. I'll never drink alcohol again. She insists that she has no injuries on her. And you don't have to take her word for it because they took photographs of her and there were no injuries on her. She insists over and over that there was no violence that day. It's like, okay, we're in a good place right now. Ask her about saying fuck you to Mr. Torres. Well, that's just being playful and having a good day. Everybody's having a good day. I didn't touch him, nor did he touch me. Her words. What else is found on her phone? There's a conversation between Mr. Torres's brother, and again, nobody knows who's using these phones at the time text messages are sent in these records that you're going to see. But it's indicated that there's a communication between one of the decedent's brothers and the owner of the phone that was taken that belongs to Ms. Boone. The text from the brother is, yo, my daughter told me what you did, Sarah. I don't want you around any of my daughters or nieces, nephews. And that's Christmas,
Agreed.
2019, just under 2 months before this event. She replies, or the person using her device at this time, ugh, your quote unquote dad hit me in the face. The next text is, hide and seek, I shall. January 13th, there's another heated discussion. She describes it on January 13th in a text to Mo, the brother again. It's a Torres thing. Boo. Sends a picture. Keep the fugly creep out too. It's still fugly. Lose. The brother responds, please do something with yourself, Sarah. God bless you. The defendant's response, and bless you and all of you too. I'll get, in all capitals, rid of him. Then it'll be, in all capitals, better. Ugh, Torres, referring to Mr. Torres, getting rid of. And that's the case. That's what the evidence is going to show. But we, the state of Florida, and the members of the jury in our journey,
Sure does.
we're all going to come up to a door that says, danger, keep out, stay away, by court order. And that door says, the defendant's history with the victim. It is a door we shall not enter without permission and invitation. Halloween in like 13 days. Part of the vampire lore is vampires can't come get you in your house. Well, I participate during this trial. We're going to be invited in to the defendant's past relationship for the previous couple of years with Mr. Torres. And as we come inside this room, at her beckoning, we are going to have things pointed out that she would like us to focus on. And you're going to hear the first night the defendant met the decedent, Mr. Torres, he smashes her phone, punches her. It's the first time in her life she'd ever been punched, I expect the testimony will be. And he made her curl up in a fetal position on her own porch for 4 hours, and she was only able to escape this situation when he fell asleep. I expect that you're going to hear that Mr. Torres is an alcoholic. I expect you may hear his high score on his blood alcohol level was a 342 once when he got treated at the hospital. This
This is a man who had serious alcohol problems, and I expect you're going to hear about that. Despite that first date, and this is going to tie into some other things that I expect could possibly come in. Despite that first date, despite at that point in time of this first date not having a relationship, emotional ties, and the things that come along with a relationship that make it harder to break off a relationship, it's one thing to have a bad first date. It's another thing to end a 25-year marriage. Despite that first date, there's a second and a third. Now, these days are at bars, and there's nothing wrong with that. And it just typically ends up, she's going to tell you, I suspect, or you're going to hear that she said, one way or another. It's one thing or the other. Like, I ask a dude for a cigarette, Mr. Torres flips out, and I'm going to pay the price. Just things like that. And you're going to hear and potentially see, yes, there were injuries that the defendant is going to attribute to the victim causing her. Black eyes. Cuts in the face, perhaps from the curtain rod incident that was mentioned in the police interview, happened about a month before this. Bloody ear. A stab wound in the leg, which is perhaps described as sword fighting, playing around in medical evidence. But nonetheless, I suspect you're going to hear and see a lot about their past history. And at the end, if this occurs, if this comes in, the state is going to have the opportunity to take lead of the tour in this room labeled the defendant and the victim's past history. And I'm not going to go into that now. If this all comes to fruit, the fruit blooms on the tree during the trial, we'll discuss it at the end where it's more appropriate. But I'm asking you to not rush to judgment until you hear all of the evidence in the case. And then apply whether or not these past instances have anything to do with what happened on February 23rd. Now, like a home inspector, there are experts to come in and kind of help walk everybody through this room labeled the defendant and the victim's past relationship. I suspect there's a chance you may hear from some experts, psychologists and psychiatrists, about battered spouse syndrome. The state is not challenging in any way that battered spouse syndrome exists. It's well recognized. The experts will tell you all about it. Not disputing that at all. But there's some things that we would hope that you pay attention to during all the testimony, if there is any, about this subject matter. One is that it's not actually a recognized diagnosis in the Bible that they use in mental health called DSM-5. Diagnostic Statistical Manual, version 5, and I think it's text revision or something like that. What it is, and what they describe it as, is kind of a component of post-traumatic stress disorder, PTSD. But because it's not actually in the book,
yeah, it's frustrating.
It's like a recipe book. It's like our statute books for lawyers. You go into this book and say you have a particular disorder or diagnosis.
But what he's doing is standard practice. There's just not a mic there.
Some of these elements have to be prevalent for a certain amount of time, so on and so forth. You imagine it's a cookbook. It gives you the recipe for a diagnosis.
Thank you, Beth.
But because it's not in the cookbook, you may get some disagreement about what it means between experts. Because it's kind of like grandma's recipe handed down from generation to generation without being right. But what I expect you'll hear is, it's important for people who don't have experience in certain abusive relationships that are violent to understand the control that can be exerted over an intimate partner by the other one, isolation, psychological violence, emotional violence, physical violence, sexual violence, which I suspect will be described for you as well by the defendant, perpetrated on her by the decedent. You'll hear about all this. And what it ties into at the end of the day, after we've talked about this during jury selection, is if there is a self-defense instruction read to you, this is to help you understand what an objective and reasonable person in the circumstances would do. Because years ago, we've gotten better as a society, but years ago when this was first being researched, the question would be, well, why wouldn't you leave? In battered spouse syndrome, the testimony from these experts help explain those things to people. Well, it's not that easy. You got to look at what's going on in the relationship, isolation, control, so on and so forth. And that explains why you wouldn't leave. Well, now, but turning to the facts of our case, what you're going to decide the facts are is ordinary, objective, reasonable person in those circumstances taking those actions if you get a self-defense instruction as part of that. That's what it's used for. It's not used for explaining the subjective beliefs that one holds. What you will also hear about these things is, just like any other doctor or any expert, like a home inspector. If a home inspector's report was based solely on the person who's trying to sell the house, what they say about the house, great shape. I rewired the entire thing. Brand new JDC pipes. This sucker's good to go. I'd agree with this. You're not going to take that home inspector's report unless they lift the hood, take the tires, do all the things that the box on here, Carfax does. You want an expert to get reliable information. An expert's opinion is only as good as the information that he or she relies on. They will say, yeah, you gotta take into account the credibility of the person who's giving you the story, even if it's the patient or the client that is saying all these things happen to her. You gotta find proper information. You have to check reliability, particularly in circumstances that we're discussing. Another thing that they're going to tell you is just because there's a bunch of violent nonsense going on between two intimate partners doesn't mean that spouse syndrome applies. Some people can go home and fight like cats and dogs. And that's just their day, and they get over it. They live their life to fight another day. Their cycle just spins like that. So just because you hear about those things, what the experts will tell you, doesn't mean that it necessarily applies. If this testimony comes in, I expect that Dr. Harper will say that it applies to this group. But we'll talk to her about what she relied upon to make that conclusion. We'll talk to her about some other things and take that journey together. But at the end of the day, after you hear all of the evidence in this case, particularly straight from the horse's mouth to the video, where you don't have to rely upon the credibility of anything other than your own two eyes and your own two ears, the state admits that you're going to return a guilty verdict for second-degree murder. What the evidence is going to show is that the defendant killed Mr. Torres because she decided he deserved it. Not because the evidence will show an objective, reasonable person in her circumstances needed. Thank you.
Thank you, Mr. J. Any opening remarks by the defense?
Judge, can we invoke the rule? It has been.
I've already advised the witnesses.
Okay, the rule of sequestration will be invoked. Thank you. You may proceed, sir.
Appreciate y'all being here. I was introduced before. My name is James Owens, and I represent Sarah Boone, along with Tony Henderson and Kevin Beck.
Oh, good Lord, not him too.
This is going to be a several-day trial. Obviously, it's day, Monday, Tuesday, Wednesday. We're not sure, but I'm trying to This is the flying expert with the department, and we'll know more probably within the day when we Monday, so you can plan. But I know your focus is on this case because you took a note. Ladies and gentlemen, there is no higher call than the right of way. No higher call than the right of way. And we're going to ask you again about this law. And find Sarah Boone not guilty because she was justified in the force that she used to defend herself. If that force was reasonable under the circumstances that existed between Sarah Boone and George Torres. Sarah Boone and George Torres were down and out, as you can be. Their life centered around alcohol. Both of them suffered from, used to be called alcoholism, now it's called alcohol abuse syndrome. And so day to day, they struggle with the use of alcohol. You can imagine that. It affected their jobs. It affected keeping employment. It affected even getting a job. As codependent as you can be towards each other. And you're going to learn with all that was domestic violence. And that George Torres physically abused Sarah Boone. And she suffered from the effects, the psychological effects that one suffers from repeat violence from an intimate partner. They were together over 3 years, and there were several prior incidences of violence. We've got the photographs. There were incidences where police were called who took photographs. So you're going to be able to see the evidence. And we believe the court will instruct you at the end when you're considering self-defense, which we call justifiable use of non-deadly force or justifiable use of deadly force, that you can consider the prior acts, the history of violence, the prior difficulties that the parties had. In considering her set of circumstances that she was faced with in making the decision to use reasonable force under the circumstances. And the most important thing I can tell you here today is keep an open mind. There's two sides to every story. You're going to hear the state's side, them attempting to paint her a certain way, as they've done here today in opening statement. And then you're going to hear another side. And you're going to have to weigh that. All the evidence, the credibility of the witnesses, the photographs, the videotapes, and come to a conclusion. Now let's talk about this day, February 23rd of 2020, the date of this event. This case has been pending for some time. Here we are, October of 2024. I think the evidence is going to show that they had purchased some wine the day before, but they hadn't finished all of that. So it was in the refrigerator. Many times that's how they start their day. At some point, you're going to see a video from Publix, from where they live. I believe it's Winter Park. But Publix was not too far from their apartment complex. And they took their car, they drove over there. So you're gonna see a videotape from Publix of them both going in the store about noon. And they come out with one of those larger bottles of the wine. And then, of course, there's a receipt. And the bottles are in the garbage can. Of course, there obviously is an attraction between the two. And as everybody knows, couples can have great times where things click, everybody gets along, and then we can have episodes of disagreement. And how are those resolved? Really, is what this is about. How are disagreements resolved? But George was very jealous of Sarah. And you're going to hear the testimony about that. And that he cannot, in certain situations, he can be very charming. But when his level of intoxication gets to a certain level, is when he gets sad, moody, and a lot of times eventually it involved forcible sex with Sarah Boone or actual physical violence against her. They bought the wine. It's a simple life. They don't have much money, but they both like art. They did that for a while. They both like puzzles. They did that for a while. Well, about 5 or so, the wine bottle was gone. And George had said, I want to go get some cigarettes. So there's a convenience store right close by their apartment complex. And Sarah thought he was just going to walk over there and get cigarettes and come back. But no, what he did was he got her keys, he got her debit card, and he went over to Publix and he got another bottle. And I think that was about 5:30, something like that. And again, there'll be the Publix video showing him going in, going out, and there'll be a receipt for the purchase of that bottle, and then there'll be that bottle. It will be in his garbage can along with the other bottle. Well, when he comes in with the second bottle, Sarah knows this is not good. She knows this means he's going to get to another level of intoxication. So Sarah's concerned. So she attempts to placate him, keep him busy, keep him in a good mood. They drink that bottle. Well, she drinks as well. And at some point, they're intoxicated at a high level. As some people do when they're drunk, they get silly. And they decide to play a game of hide and seek. She goes upstairs, their bedroom's upstairs, to the shower and waits for a period of time. And he doesn't come to her. At some point, she gets cold, she gets tired. She wants to go see, well, maybe we got it mixed up. Where is he? So she goes downstairs, and they had gotten a suitcase down a week or so ago. It's an old suitcase that they were going to donate to Helping Hands or Goodwill or somebody, and they were putting some items in there. And it's a broken down suitcase. It's a large suitcase. They both weigh about 100 pounds. And they don't eat good. Malnourished to a large degree. But the pull handle is broken off. And they've attached a little paper clip that's got the rubber around it. And that's how they hold it back and forth. Well, she comes down the steps. She sees him getting in and settling in the suitcase. So she walks over there, and they see each other. They smile and laugh, and she zips him up. And she zips him up, and they laugh for a while. And they carry on. She sits on the couch, And at some point, he says, I can't prove it. Now, his face is facing the zipper, and she's got 2 or 3 inches that she's opened it. And she doesn't know. They're intoxicated. She doesn't know whether he's just saying that to try to get her to get him out or what. But he's a captive audience. Physically, they're the same size, but he's much stronger than her. If they got in a fist fight, he would win 100 times out of 100. But she's got him now. He claims he can't get out. He has to sit and listen. It's a unique form of physical restraint. And so she lets him have it. Says things she shouldn't say. You'll see the video. It's about 2 minutes long. She videotapes it. She sits on the couch and turns her phone on and videotapes it for about 2 minutes. There's another video that's approximately 11 minutes later. The first video, George is, the suitcase is flipped upside down. The zipper's on the bottom. 11 minutes later, Sarah has flipped it right side up. Again, open for him to get out. And it's only 22 seconds. And you hear George say, Sarah. And that's it. Now, the key to the case is that 11 minutes. And what happened during that 11 minutes. Okay? That is the key to this case. Sarah Boone will take the stand. She will explain what happened. She will explain why it happened. The evidence will show that she was justified in the action she took.
Absolutely. It's a high-profile case.
An attack from George Torres,
He's doing a good job.
which the law
He is going to lose,
every one of us has a right to invoke.
but it's great for his career.
You can hear from the medical examiner. She is going to tell you about some bruising on George Torres. Of course, he was in the suitcase a while, deceased, we believe.
Yeah,
That
he
changes
spent the rest of his life in the suitcase.
The examiner will explain, but there's some bruising. Sarah's going to explain that to you. Why that happened. What were the circumstances surrounding that? Involving that. Her son comes and stays with him from time to time. He has his own room. He has several of his things there. And there's a bat downstairs. The same bat that George Torres used, and there's a video where George is threatening Sarah. And he's swinging the bat at the TV about as hard as he can. And he does it about 6 or 7 times. You'll see it. Sarah's recording it. And it's during an argument. And he's trying to intimidate. Sarah loved you. You know, you're going to hear why women don't leave. Why women don't leave. And you're going to hear about Sarah Boone and her struggles, her mental health struggles.
That's actually a solid analysis.
Sarah had no intent to kill. Prosecutor mentioned she wanted him to die. Farthest from the truth. She loved the man. She hated the abuse. She couldn't leave him. She tried. She tried kicking him out 6 or 7 times. He kept coming back. She changed the locks. He kept coming back. She didn't have the family. She didn't have the support. She was weak, vulnerable. You're going to hear it all. You got to take that all into account to try to understand what happened and the circumstances surrounding this tumultuous relationship. Now, you're going to find that Sarah's not perfect. And, you know, she goes, as many of us do when we drink too much, you sleep in. She slept in. 11, 12, 1, somewhere around there. She moseys downstairs looking for George. She thought he was on the computer looking for a job. She looked outside, maybe he's out smoking a cigarette, and she sees the suitcase.
Mm-hmm.
She unzips it. She gets him out. He's purple. She tries her best to do some CPR. She freaks out. The only family she's got is her ex-husband, really. She relies on him. As the prosecutor said, a lot of times she'll flee to her ex-husband's house, where her son is at, Lucas. It's the only thing she knows to do. She was kind of a sheltered daughter when she was younger. She's smart, but she's not worldly. She calls Brian. What do I do? He said, I'm coming over. Please come over. He's about 5 minutes away. And she calls him again within a couple of minutes. Yeah, I'm on the way. He gets there. He walks in the foyer and sees his legs. And she called 911. She calls 911 within a minute, 2. Detective Rodriguez arrives. You know, they got the body cam now, so it's recorded. So you're going to hear Sarah talking. But Sarah's freaking out. Sarah's thinking, and I'm somehow responsible. Eventually, she gives a statement to law enforcement. She gives one to Detective or Deputy Rodriguez. Of course, she's not the homicide investigator. She's just responding. She's the first responder. And, you know, they know what to do. They try to assess the situation. They start putting the tape out. And then they call for the homicide investigators to come, which takes a little time. So she gets a statement from Sarah. Eventually, the homicide detectives get a statement from Sarah and one of the unmarked squad cars. And it's recorded. They hear that. And then the next day, they take Sarah's phone. Sarah gives them the phone, signs the consent to take the phone, take it to, they have a phone extraction people at the sheriff's department where they can take it and take out all the data, all your phone calls, text messages, photographs, videos, all of it. And they find these 2 videos. Sarah's not aware. She doesn't remember making the video. You can imagine. She gives them the phone. Well, she makes no attempts to
anything other than, here's the phone. So they tell her, you're gonna get your phone back tomorrow. We'll bring it back to you tomorrow. Well, they end up having a conversation with the female detective, homicide detective, Copson is her name. Chelsea Copson. And they end up, Deputy Copson was pregnant, or Detective Copson was pregnant. They said, hey, we're not gonna bring your phone. I'm not feeling good. I'm pregnant. Can you come to the sheriff's department? Which Sarah Boone was telling you that was what I was going. That's what they told me I was going to the sheriff's department for. Well, instead it was an interrogation. And they were going to arrest her. They made their mind up already. And they were going to confront her and try to get her to confess based on the 2 videos. And so there's approximately a 2-hour interrogation that was on the 25th in the afternoon when she got there to get her phone. They said, well, we got to come up here. We need to talk. And they got her in the room. It's a small room, but it's being videotaped and audio taped. And it goes on for about 2 hours of them trying to get a confession to murder. And it doesn't happen. But Sarah lies. She's scared. She can tell they're trying to pin her on this, that this was some kind of intentional act, and it was not. So she lies. She's not a lawyer. She doesn't know about self-defense. She doesn't understand she has a lawful right to defend herself. She doesn't understand that she's justified in using the force that she used. She doesn't. I wasn't there to advise her. No lawyer was there. So she lied. And you're going to hear that. So you're going to have to balance that versus her taking a stand and testifying for you. And we simply ask that you look for the evidence of cooperation of her testimony. It's going to be later, probably next week. The judges will tell you in reading instruction on evaluating a witness's credibility. And they'll talk about evidence, other evidence that's consistent with the testimony that Sarah Boone will give you. So you're going to have to weigh that in her testimony. Now, self-defense, we talked about it in jury selection, usually a gun, some deadly weapon. The suitcase in this case was a physical restraint or a blocking of an attack, but it was unconventional. Self-defense nonetheless. Now, as I said, the struggles that occurred, many of them involve the police. So you're going to actually hear from some of the police officers. Maybe some body cam footage. You're going to see some photographs that they took of the injuries to Sarah Boone. And some of the videos you may see of her in a very happy, joyful type of thing. Well, number one, she's intoxicated. Number two, she's safe. The police are there. So her attitude is not one of distress. We're here today, full packed courtroom. Judge Craddock's here, but you're the most important people because you've got to decide this case honestly, fairly, and according to the law. And we talked about the two biggest principles from the Constitution that apply. In this case, and in every case in which a citizen like Sarah Boone is brought into a courtroom and accused of a crime. The first is, you as a juror must presume or believe that Sarah is innocent. And that belief stays with you throughout the entire trial. Because of that, she doesn't have to prove anything. That's why the state went first in jury selection. That's why the state went first today. That's why the state will go first putting on their case. They have the burden of proof, and it's the highest burden we recognize in any type of litigation in this country. Proof beyond and to the exclusion of every reasonable doubt. You are going to have doubts about this case. But the most important thing is not to rush to judging, to keep an open mind and understand there's two sides to this case. There's their side and there's our side. So you can't form any fixed opinions early on. That's hard to do, as Mr. Henderson said in jury selection. That's extremely hard to do. Now you're going to hear some testimony. There's been mention of experts. Battered women's experiences affect her perception of imminent danger. Battered women's experiences affect her perception of imminent danger. Victims of repeat violence may fear death in a situation others would not. After hearing both sides of this case, we're confident you're going to have a reasonable doubt. And we're going to ask you to follow the law and do justice in this case. And find Sarah Boone not guilty, because it's the right thing to do. Thank you.
Thank you, sir. Can the parties approach for a moment?
We've been listening to opening arguments in the Suitcase murder trial. We do know that the prosecution went first. The defense just delivered their
I don't need Super Nerd's version of this here. Both attorneys did a damn fine job with opening our opening statements. They really did. Including the defense attorney, I think he did a really good job with it. I don't believe any of it. His client's guilty as hell. But he made the arguments you could make with these horrific facts. And it's a non-trivial defense. I don't believe it. I believe she will be convicted. She should be convicted, and that she's guilty as hell. But that's as well as you can do. Is you two things that he's saying it's self-defense, and that I don't believe any of this, but it's self-defense, and that when he goes for a second bottle of wine, he's going to get drunk and beat her up or something. I'm just not buying it. The dog doesn't hunt, but that sets up some justification for doing it, and then he wants to throw in there. Essentially, he's attacking the element of intent. I didn't intend for that to happen. Oh wait, we might have somebody back here. The nerds are off. I don't need to hear the Fox nerds. Just filling holes, huh, Andrew?
Sir, good morning. You could be seated. And once seated, if you'd state and spell your name for the record for us, please.
Juan Torres, Juantorres.
Thank you, sir. You may inquire, Mr. Cacciatore.
Good morning, sir.
Good morning.
Can you tell us how it is that you know George Torres?
He's my older brother.
And how many siblings do you have?
Six or seven.
And how long has your family resided here in the Central Florida area?
20 plus years.
And before residing in the Central Florida area, were you guys in Philadelphia, Pennsylvania?
Yes, sir. And Massachusetts.
Your brother, how often, your brother George, that is, how often would you talk with him?
Often we talk, say, on a weekly basis.
And how far away did you live from George?
About 5-10 minutes. Pretty close.
Would you see him pretty often?
I would try not to go over there too much.
Who was George living with at the time that he passed away?
Sarah.
And without getting into many details, what was your relationship like with Sarah?
We didn't really have a relationship.
Would it be fair to say you didn't get along with her?
Yes.
Back on February 23rd, 2020, did you have an occasion to talk to your brother on that day?
Yes, sir.
And when you spoke with your brother on that day, did you
This is gonna be
FaceTime
rough.
with him or did you speak with him over the phone?
We talked on the phone.
Was that phone to your ear or was that phone?
It was on speaker.
And who was present?
My wife and my 2 kids.
And without telling us anything that George may have said to you, can you tell us what the topic of that conversation was?
We were just talking like we normally did. He just calling me to check on me, basically.
Now, in the background of that conversation on the evening of February 23rd, 2020, what did you hear?
Sarah's in the background yelling.
And you recognized her voice?
Yes.
What was she yelling about?
Something about choking or how he choked her. I really don't. That was it.
About how long was this conversation that you had?
Maybe 10 minutes, I think it was.
How did the conversation end?
Because she was yelling in the background. So that was it.
Did she sound upset?
She sounded upset.
Did you talk to your brother after that conversation?
No, that was the last conversation I had.
Have you ever spoken to Sarah since that conversation?
No.
I have no further questions.
Any cross-examination?
Good morning, sir.
Good morning.
In the beginning, when you started, it was hard for me to hear, but I know you were talking about other siblings, other family members that you had. here. Could you repeat that for me, please?
Here in Orlando, I have one sister and 3 brothers.
Sister and 3 brothers?
Yes, sir.
Okay. Now, did your brother George Torres, did he ever stay with you at any time?
No.
Would he ever live with you or any of, I mean, not you, but any of your other siblings?
No.
All right, sir. Let's go back to this phone call that you were talking about that was on February 23rd of 2020. And that phone call was approximately 7:30. Is that correct?
Yes, sir.
All right. And who called who?
He called me.
And then y'all were talking. Is that correct?
Sir.
All right. And when he called you, did you notice anything about his speech or his voice?
No, he was fine.
Sounded normal?
Yes, sir.
Okay. So he wasn't slurring his words or anything like that?
No.
By the way he talked or what he talked to you about, could you tell at that time if he had been consuming alcohol?
No, because I knew when he would drink.
Okay. So in your opinion at that time, based on what you heard and what he was talking about, you do not believe he had been drinking alcohol?
No.
Now, you said you heard Sarah.
Yes, sir.
Is that correct? How did you know it was Sarah?
I could tell in her voice.
You recognized her voice. So you could hear her. Is that correct?
Yes.
All right. And you've heard Sarah speak before that time. Is that correct?
Yes.
And you've heard her speak on the phone before that time. Is that correct?
Yes.
And you said that Sarah was yelling. Is that correct, sir?
Yes.
And she was yelling about, he's choking me. Or tell him about choking me.
Yes.
Okay. During that conversation, and you heard her say that, did you ask your brother, what is she talking about?
No, I did not.
Did that statement at that time, did that statement surprise you?
Not really.
You've heard it before?
No.
Based on Sarah's voice that you've heard, was it any indication to you that she had been drinking?
No.
No? Sir, at some point your brother said he had to go, is that correct?
Yes, sir.
And did he hang up on the conversation?
Yes.
And did he say bye and you say bye?
Yes.
Thank you, sir. I don't have, if I can confirm.
You may, sir.
Sir, other than siblings, your mother and father, do they live in this area?
Yes.
Were there times that George would stay with them?
Yes, sir.
Thank you, sir. No further questions.
Any redirect examination?
No, Your Honor.
Can this witness be released?
Yes, Your Honor.
Defense?
Actually, we'll keep him subject to recall, Your Honor.
Okay.
I would agree with that.
All right, sir. You're released subject to recall by either party. Thank you.
State would call Devin Jamro.
Well, they are getting right after it. I thought they would just break for lunch after the opening statements.
Sir, good morning. You could take a seat and please state and spell your name for the record.
My name is Devin Jamro. That's DEVINJAMRO.
Thank you. You may inquire, sir.
Sir, who do you work for?
I work for Public Supermarkets.
And what is your position with Public Supermarkets?
I am the assistant store manager.
And at what location?
Currently the Castleberry location.
Were you at the location on Goldenrod and University Boulevard back in February of 2020?
Yes, I was.
Your Honor, may I approach the witness which has been previously marked for identification as states D and been shown to defense?
D is in Delta?
D is in Delta.
Yes, you may.
Sir, I'm showing you it's been marked for identification as states D. Could you use these scissors and open this and look at the contents of this package to yourself?
Sure.
Sir, do you recognize those items?
I do, yes.
And tell us, what are these items?
These are Publix receipts.
Are these receipts evidence of transactions at Publix? Are they made at or near the time of each transaction?
They are absolutely made at the time of the transaction.
And is it in the normal course of business that Publix keeps these receipts?
Yes.
And these fairly and accurately appear to be the receipts from your Publix store?
Yep.
Your Honor, at this time, I'd like to move what's previously been marked for identification that states D into evidence.
Any objections?
No objection.
What was pre-marked as states D will be received into evidence without objection as states 1.
Your Honor, may I approach the witness who's been previously marked for identification as states J and shown to defense?
You may.
Sir, I'm showing you it's been marked for identification as states J. Can you take a look at that disc?
Yes,
Do you see your initials on that disc?
I do.
Did you have an opportunity to look at that disc prior to coming to court this morning?
I did, yes.
And tell us, what is that disc?
This is CCTV footage burned from the camera system at the location.
And at Publix, is it the regular practice of Publix to utilize surveillance cameras?
Yes.
And in the normal course of business, are the videos from those surveillance cameras kept?
Yes.
And are these the cameras taken from February 23rd, 2020? And I believe there's 2 video clips included, one at 12:17 p.m. and another at approximately 5:39 p.m.
Yes.
And they fairly inaccurately represent the surveillance video that was submitted from Publix to law enforcement in this case.
They do, yes.
Your Honor, at this time, I'd like to move what's previously been marked for identification, the state's J, into evidence.
Any objections?
No objection.
What was pre-marked as states J will be received into evidence without objection as states 2.
Oh, good Lord. Why didn't you just work out the foundation before trial on that?
Any cross-examination? Can this witness be released?
Yes.
Thank you, sir. You're released.
Thank you.
Have a great day.
Back to good old
State, you may call your
Publix.
next witness.
State would call Joan Williams.
I miss Publix. I could go for pub sub. Some of those wings. I know when they testified that there was or when he argued that there's a Publix nearby, I thought, I don't think you can get more than 20 minutes away from a Publix anywhere in the state of Florida.
Ma'am, good morning. Could you state and spell your name for the record for us?
Okay, Joan, Joan Williams, Williams.
Thank you, ma'am. Counselor, you may inquire.
Good morning, ma'am.
Good morning.
Can you tell us what it is that you do for a living?
I'm a 911 call taker at the Orange County Sheriff's Office.
And how long have you held that position?
24 years.
And tell us, what are your duties as a 911 call taker?
I answer phones for an emergency, non-emergency, medical, we try to transfer to the medical side of the business.
And is it the regular practice of Orange County to record 911 calls?
All lines are recorded.
And is it the regular practice of Orange County to keep records of each of those 911 calls?
Yes.
And those records are made at or near the time of each call, correct?
Yes.
Your Honor, may I approach the witness which has been previously marked for identification as states L and been shown to defense?
May.
Ma'am, I'm showing you what's been previously marked for identification as states L. Do you recognize this disc?
Yes. My initials.
Did you have an opportunity to review this disc prior to coming to court this morning?
Yes.
And those are your initials on the disc?
Yes.
And does this disc, does it fairly and accurately represent the 911 call that you took in this case on February 24th, 2020 at 12:59 hours?
Yes.
Your Honor, at this time, I'd like to move what's previously been marked for identification as states L into evidence.
Any objections?
No objection.
It was pre-marked as states L will be received with no objection as states 3.
Your Honor, I have no further questions.
Any cross-examination?
No, sir.
Can this witness be released?
Yes, Your Honor.
Yes.
Thank you, ma'am. Can the parties approach momentarily?
Okay, so that was just a bunch of foundation. They chose, which is, I think, wise, to
We are
lay all the
watching the
foundations.
state of Florida,
Shut
the
up,
Sarah
nerd.
Boone. This is the Suitcase murder.
They chose to lay all the foundations so that when they get to these sort of story, they want an uninterrupted narrative. So they're getting all this evidence in, so they can play the tape of at the grocery store purchasing wine right after, and the video of him in the suitcase and the calls afterwards to 911 or whatever. They would just want to do that right in a row and not have it interrupted by this foundational nonsense. So that's all that was going on there. I would guess that they're going to break for lunch right now. I'm sorry. I won't let it happen again. And apparently I was wrong. We're going to keep going.
Sir, you may be seated. After you're seated, if you can state and spell your name for the record for us.
Vincent Battaglia, Vincent Battaglia.
Thank you. Sir, you may inquire.
Good morning, sir.
Good morning.
Can you tell us what it is you do for a living?
Right now I work for an auto parts company,
And where do you live?
New Jersey.
Back on February of 2020, where were you living at that time?
I was living at the Tealwood Apartments in Winter Park, Florida.
And what were you doing at that time when you were living at Tealwood?
I was enrolled in Full Sail University. I was in school.
When you were living at Tealwood, did you have any roommates?
Yeah, I had one roommate, Brandon. Yeah, that was it. Him.
That's Brandon Motes?
Yes.
Okay. Did you have neighbors?
Yeah.
Were you neighbors with Sarah Boone and George Torres?
Yes.
And approximately how long were you neighbors with them?
About a year, a little over a year. I moved there in January 2019.
And during the course of that year that you were neighbors with them, did you have occasion to interact with them at times?
Yeah.
In fact, did you ever go over to their home?
Yeah, like a couple times, yeah.
And I believe you tuned a guitar for the child there at the house?
Yeah.
This Tealwood apartment complex, how would you describe the walls that separated your units?
Thin, like very thin walls.
And with those walls being so thin, would you ever have occasion to hear arguing and yelling coming from Sarah Boone and George Torres's apartment?
Yeah.
How often would you hear this?
Almost daily.
Did Sarah Boone ever approach you about the things that you heard coming from their apartment?
Yes.
And where were you when she approached you?
I was smoking a cigarette on my back patio.
And approximately what time?
It was
this?
pretty late. I can't remember the exact time, but it was definitely anywhere between like midnight to 2 a.m., like right around there.
And do you remember how much before the date when the police called that this occurred?
A few months, like probably 4 to 5 months before that.
So 4 or 5 months before February of 2020.
Yeah.
And when she approached you on this late evening / early morning on that day, what did she tell you?
Pretty much just kind of like, if I do hear anything, like through the walls or whatever is out back, just kind of keep my mouth shut. Like, don't really speak about it or anything like that, or say anything to anyone. And I just was like, okay.
Did she make any motions with her hands?
Yeah, like just kind of like, you know, finger over the lips, like kind of shh, like keep it hush, like that kind of thing.
Interesting.
She told you not to report anything you may have heard about arguments or yelling or fighting, anything going on over there.
Yeah.
Do you recall the evening of February 23rd, 2020?
I do, yeah.
And what about that evening sticks out to you?
That sticks out to me from that night was literally just there was a very, very loud noise that I heard that was loud and powerful enough to shake my bedroom wall. And I remember that because I was sitting on my bed on FaceTime with my girlfriend at the time, and I literally felt the wall shake and it stopped me mid-conversation. And she even asked me through the computer, like, what was that? And I was like, I have no idea.
Did you hear any yelling coming from their apartment on that night?
Before that, yeah, like it was just arguing kind of stuff.
What was the last thing you heard?
The last thing I heard was like the loud noise and just a little bit of shuffling, and that was kind of it. It just kind of went silent after that.
Could you hear anything that was being said?
Not clearly, and it was never really anything clear. It was just like you could hear arguing back and forth, just kind of like and kind of like an I hate you, like it's whatever it is, whatever the argument was about kind of thing at the time. That's really all it was, but it was never really clear enough to hear like the full argument. And honestly, I never really paid attention too much to it. If I heard it, I kind of stepped into my living room to be further away from it.
Did you hear both the defendant's voice and also George Torres's voice?
Yeah. All the time. It was like a back and forth. Yeah.
So other than the statements and the phrases of I hate you, you weren't able to discern the contents of this argument?
No.
What was the last sound you heard?
The last sound that I heard was like the loud banging noise that it was like a very odd sounding noise that I've never heard before this day, but it very much sounded like it was where my bed was positioned. It was kind of towards the back of the apartment, and it almost sounded like it was coming towards me, but like on the side of me, you know. Then it was just like a loud rumbling noise, like that literally sounded like it was kind of far away from me, and then it like ended up like almost next to me. And like I said, the walls are thin, so like it's very easy to hear like through the walls, and not even just sideways. Like I hear my upstairs neighbor, like all around, very thin walls.
Now, was your bedroom, where was it located in your apartment?
The back of the apartment. So it was like, there's like a little kick out next to my patio, and that's like, that was my bedroom back there, like along the grass back there.
On the first floor?
On the first floor, yeah.
I have no further questions.
Any cross-examination?
Mr. Cagley, good morning.
Good morning.
Now, you said that you lived there next to Sarah Boone and George Torres for about a year?
Yes, sir.
Are you aware that the police were called to their residence?
Like
while you were there for the year, are you aware of any incident in which the police were called to their residence?
had never seen anybody there, but I had had other neighbors in the complex tell me that it has been on multiple occasions. So that's why.
Just instead of what somebody else told you,
Yeah.
just what you would observe. Did you ever, the year that you were there living next to them?
Yeah.
Were you ever aware that the police were called to their residence?
No, the times that I was home, I never saw any police at the apartment there.
And did you work odd hours or you went?
Yeah, and with my schooling and stuff too, I used to have class at like 1 o'clock in the morning. So all the time I was at random moments, like just not home throughout the day and night and stuff like that. So yeah.
Do you have an opinion as to whether or not, based on your interaction with Sarah Boone?
I'm going to object.
Let me finish the question first, please.
Do you know from your experience with Sarah Boone and your experience with George Torres that they drank alcohol?
Yeah.
Hang on.
I'll withdraw to that question.
Okay, thank you.
Yes.
Are you aware that they both consumed alcohol to excess?
Yes.
Thank you. Hold on.
Yes, sir, of course.
Vincent, I think you had testified, you may have given a statement to law enforcement,
Yes, it was one of the detectives.
a recorded statement.
Yes, I can't remember his name, but yes.
Okay, and I think it was on February 23rd of 2020.
Yeah, right around that time, yeah.
I believe you had said that,
I'm going to object as to improper impeachment.
Approach.
The lawyers have approached the bench discussing their legal issue with the judge.
No, that day I actually got home from work probably around 1 or 2 o'clock or so.
in the morning,
No, in the afternoon. Because I went to work that morning at around 5 a.m.
and you said that you heard the normal yelling and arguing at about that time when you got home?
No, it was around that time, but it was really around like 10 o'clock, 10:30 is when like the arguing I could really hear clearly. It was like around 10:30 at night.
Okay, thank you. Thank you.
Any redirect?
Just very briefly.
Yes, sir.
So on cross-examination, you were asked about the arguing you heard, and I believe your testimony was that it was pretty intense around 10:30.
Yeah.
Approximately what time was it that you heard this loud crashing thump sound that you described?
Little after that.
Overruled.
It was a little after that arguing and stuff. It was probably around 11:15, probably 30, 45 minutes after like the arguing I could hear started.
No other questions?
Can this witness be released?
Yes, Your Honor.
Not subject to recall.
We would like him subject to recall. We've got his number.
Okay.
Your Honor, may we approach?
Yes.
I'm wondering why they're going up to talk to the judge. I'm waiting for Fox to explain it to me. Bad Mike.
All right, sir, you are released, not subject to recall. Have a great day. Thank you.
The state would call Brandon Moats.
Bless you. Thank you, sir. You can be seated. State and spell your name for the record for us.
Yeah, my name is Brandon Moats, BRANDON MOATS.
Thank you. Mr. Cacciatore, you may inquire.
Good afternoon, sir.
Good afternoon.
Can you tell us how it is that you knew Sarah Boone?
I moved into the apartment next door to her when I was in college.
And so, when was that you were in college?
I would have moved down here in 2019 and would have been there until like 2021, 2022.
So she was your neighbor at Tealwood Apartments, is that correct?
Yeah, it would have been Tealwood back then, yeah.
And did you have any roommates back then?
Yes, I was rooming with Vincent Battaglia.
And
Yeah, I might
during that
go back
time,
to that.
What were you doing?
Like,
as far as work and school. And
I was just going to school. During the time of this, yeah, I would have just been going to school. I don't think I would have had my job yet. I was just a student.
Did you have much interaction with the defendant or with George Torres?
He's a lumberjack and he's okay. He sleeps all night and he works all day.
The apartment where you lived, tell us, how would you describe the walls that separated the units?
Yeah, I remember that my bedroom was like the front facing bedroom and our walls shared a wall with where their staircase was. So like the way the apartments were laid out, we had a 1-story apartment, they had a 2-story apartment. So they had a staircase running right next to the walls next to like our bedrooms.
Would you ever have occasion to hear arguing and yelling going on inside of the defendant's apartment?
Yes, the walls were pretty thin. So if people were yelling, you could definitely hear it.
And how often would you hear arguments or disagreements going on over there?
When I first moved in, it was it was at least like once a week, to the point that I started tuning them out. Like I got good enough at just like not listening to them. They argued very, very often.
Do you recall the evening of February 23rd, 2020?
Yes, sir.
And on that evening, could you hear arguing going on in their unit?
Not late into the evening, earlier into the evening, probably like 7, 8 o'clock that evening, probably like earlier on, I could hear arguing.
And where were you inside of your apartment?
I would have been in my bedroom pretty much all night.
And your bedroom, just so that we can paint the picture, where would that would have been, on the first floor or the second floor?
We had a first floor apartment.
Okay, so all the units were, or all the bedrooms were on the first floor.
Yeah, like I was saying before, we had a 1-story apartment, and then they next door had like a 2-story townhouse. So we only had the 1 floor.
Understood. And at a certain point in the evening, did you hear a loud crashing sound?
Yeah, probably around 10:30, 11 o'clock that evening.
And can you describe that sound for us in more detail?
I mean, yeah, at literally, like I said, at like 10:30, 11 o'clock, it's the way their staircase was set up. I could, my bedroom, the top of their staircase would have been like above my ceiling. And it ends next to where like my roommate's apartment was. So I could hear something start above me super loud and then fall away from me like it was falling down the stairs.
Did this affect the walls that were between your two apartments?
Oh yeah, me and my roommate, I remember me and my roommate talking the next day about like we could literally like it shook both of our rooms.
Did you ever have occasion to talk with the defendant about what happened?
I never saw her after that. She would have, I never saw her after that happened.
No further questions.
Any cross-examination?
Good afternoon, sir.
Good afternoon.
Sir, you were asked by the state if you ever had any interactions with Sarah Boone or George Torres. Is that correct?
Yes, sir.
And I think you said you tried to avoid them.
Yeah, I don't like drunk people, and they were drunk a lot, so I did not interact with them.
Do you remember this interaction with Sarah Boone in 2009 when you woke up and witnessed Sarah?
I would have been 9 years old in 2009.
I'm sorry, 2019. Good catch. In 2019, when you woke up and witnessed Sarah sleeping on the concrete patio.
Oh, this may have been a slight misconception in how I said this. I never woke up and saw her sitting on the patio myself. That I would have seen her on the patio eventually, but it's not like I woke up and went back and saw her on the patio. This was my roommate relaying the story that she had fallen asleep on the back patio, and then I like saw her.
So you did not witness that yourself, or did you see her?
I saw her asleep on the back patio. I was just clearing up the sequence of events there.
Okay, thank you. Another time, do you recall our interaction with Miss Boone when you were coming home from school and she was trying to talk to you and she seemed paranoid and rambling?
Yeah, I had gotten locked out of my apartment, so I was waiting on the steps I was like waiting on the steps outside of my apartment for my roommate to get home. So she came up and started talking to me. I don't really remember too many like details of what she was saying because I didn't want to talk to her. She did, but
Okay, I kind of like him now.
Do you remember saying that you believe Sarah was avoiding going into her apartment?
that's definitely the vibe. I don't remember what she was saying, but like the vibe she was giving off was that she didn't want to go home.
Now, I believe, and I just want to make sure that I heard you. You said that the first arguments, other than the boom, which was like 10 something, initially it was around the 7 p.m. You heard arguing.
It would have, yeah, because it would have been. I remember that day I got home from class around 5, because I got out of class around 4:30 usually and walked home, so I would have gotten home around 5:30, and it would have been after I took, because I came home, I made myself lunch, and I took a shower, and then I heard all of their arguing, so it would have been about an hour and a half, 2 hours after I got home, so around 7 to 8 o'clock.
And during that time, when you
No one objected.
was it back and forth?
It's in.
I honestly, I wouldn't really be able to say if it was back and forth. I don't know I wouldn't remember too vividly if it was back and forth. or if it was
Let me
just
ask you
one
this,
person
did you
yelling.
hear a male voice?
Yes, I heard a male voice.
Did you hear a female voice?
Yes.
Okay, were they both loud?
Yes.
If I can confirm, Judge.
Yes, sir, of course.
I mean, this guy is credible. He's like, I had neighbors. They were annoying drunks. I avoided them like the plague. I still observe things against my will, but that's all I can tell you.
Thank you, sir. I have no further questions.
Any redirect?
No, Your Honor.
Can this witness be released?
Yes, Your Honor.
Subject to recall, Judge.
All right. All right, sir, you're released subject to recall. Thank you. Can the parties approach?
All right, we have now heard testimony from several witnesses that the state has called this morning.
Shut up. It's going to become an issue for me.
All right, sir, you are released, not subject to recall. Have a great day. Thank you.
The state would call Brandon Moats.
Fox has better sound. I don't really have a problem with Super Nerd, but I don't want to hear it.
Bless you.
I think the difference in sound was simply Fox had someone over there who was jacking the volume up and down as they were near or not near a microphone. Whereas this feed is just like, deal with it. What is going on here? This already happened.
Thank you, sir. You can be seated.
So court TV is delayed. Like how big is the delay? I was just over there. I can't figure it out. Just deal with Fox. I mean, I have no love for either of these organizations, but I am poaching their stream. It's a real dogfight to figure out who sucks less. In fairness to these two organizations, I feel that way about all of them. There's like nothing they could do. I'm not fair. I'll just declare that right now. There's nothing they could. There's nothing this legacy media could do to win me over. I left that reservation about 30 years ago, and I'm not going back.
Members of our jury, thank you so much for your time, your attention, and your participation in this very important process. It is 12:21. At this point in time, we're going to go ahead and take our lunch break. I'm going to ask that you return here no later than 2 p.m. so we can pick up at that point in time outside of here, 12 Alpha in the Orange County Courthouse. And I'm going to give you an instruction. You're going to hear this instruction a lot over the next couple of days. Jurors, you must not conduct any investigation on your own. This includes reading newspapers, watching television, or using a computer, cell phone, the internet, any electronic device, or any other means at all to get information related to this
Except Law
case
Talk with Mike.
or the people and places
Law
involved.
Talk
in
with
this
Mike
case.
is encouraged.
This applies whether you are in the courthouse, at home, or anywhere else. You must not visit places mentioned in the trial or use the internet to look at maps or pictures to see any place discussed during the trial.
No Publix.
Jurors, do not watch local news or read local newspapers. Jurors
That's
must
right.
not have any discussions of any sort.
You're all
with
going to have to
friends,
suffer through it Win
family
Dixie for a
members,
couple
or
days.
even your fellow jurors.
I know it's not the
case
same.
Or the people and places involved. So do
But
not
that's
let
the way it's
anyone
gotta
make
be.
comments to you or ask questions about the trial. I want to stress again that just as you must not talk about this case face to face, you must not talk about this case by using an electronic device. You must not use phones, computers, or other electronic devices to communicate.
Yeah, good point.
Do not send or accept any messages
I
related to
can't
this
be
case
having this.
or your jury service. Do not discuss this case or ask for advice by any means at all, including posting information on
Here we
your
go.
website, chat room, or blog. With that, members of
Take
the jury,
that.
please leave your pens and your notepads on each chair. The deputy will collect them. We'll see you at 2 o'clock, and I thank you for your service.
2 o'clock. What is this? 12:25. So it's an hour and a half from now. I don't know. What do I do with this thing? Let me take my banner down now. I don't need to troll myself.
State, anything we need to address? Defense. All right, Ms. Boone, I just got a couple of inquiries of you, ma'am, before we release.
Oh, wait a
Are you
second.
satisfied with your attorneys so far throughout this trial? And are you on board with the strategy that they've employed so far in this trial? All right, thank you very much. We'll be in recess till 2 o'clock. Court's off the record.
Sarah's on board. Good to know. That's interesting. That's interesting that we had that inquiry. Obviously trying to address any BS up front. Because you know there will be an ineffective assistance of counsel claim when she's inevitably convicted here. Because there always is, because it's one of the only appeals you can always make. You think it'll be a plea? I mean, that would make sense. I don't know how cranked up these attorneys are at each other. They did offer a plea deal. Now we've drug everybody down here. That doesn't preclude them from entering into a plea at this time. It's actually an interesting notion. Should I do? I didn't want to get sucked into this. Should I do this the rest of the day? Is anybody going to watch this if I do it at 2 Eastern? I'm certainly not sitting around here for an hour and a half. I've got Law Talk with Mike things to do. Actually, I've got to check in with Yesenia and get my list of tasks. I did do a hearing in the middle of this. I did. I did. Well, this was going, but I mean, it was long. You know, what can you do? I was multitasking. So I just slid in there, took care of my business, and came back. All right. How long is this thing gonna go? How long is this trial gonna go, people? All right. All right. We'll do that. 2 weeks, no way. All right. I'll set up a stream. Well, we'll do the rest of today at least. I can tell you right now, I want to see her testify. I want to see the closings. But I don't know if there's anything else that I want to see. The playing of the video of him in the suitcase, which everyone's probably already seen, is going to be brutal. It's only a few minutes, but it's going to be brutal. So far, I think both attorneys, it's not just the two attorneys, but I'm thinking specifically the two that gave the opening statements, but the teams on both sides are doing just fine. I got after the prosecutor for being whiny a little bit in the pretrial motions, but that's small potatoes. That was nitpicking. His opening statement was quite good. The defense opening statement was quite good as well. She's guilty as hell, and that's where we're headed. I'll see y'all back at 2.